Thank you for joining us today. My name is Tom Van Der Rostein, and I serve as the president of the Louisville Forum. We meet on the second Wednesday of every month at Vincenzo's Restaurant. The Louisville Forum is a nonpartisan public issues group founded in 1984. The Forum hosts debates and discussions of contemporary and sometimes controversial public policy issues that affect the greater Louisville community. Although we may take up issues that have a national interest, we try to highlight the local perspective. For more information on the Louisville Forum, our programs, or to make reservations, please visit our website at louisvilleforum.org. Our topic and speakers today are Marsy's Law. Would it balance or tip the scales of justice? The question on the ballot this November is, are you in favor of providing constitutional rights to victims of crime, including the right to be treated fairly, with dignity and respect, and the right to be informed and have a voice in the judicial process, end quote. The referendum as written would amend the Kentucky Constitution. The proposed law is named for Marsy Nicholas, a young woman who was killed by an ex-boyfriend. That ex-boyfriend was then out on bail when Marsy's mother and brother encountered him in a grocery store. They had not been notified of his release. That brother, Henry Nicholas, became a billionaire, and he is the prime source of funding behind Marsy's Law campaign. Since 2008, a national campaign entitled Marsy's Law has sought to enshrine in state constitutions in the United States a specific and lengthy set of victims' rights. Kentucky is one of 15 states that makes no mention of victims' rights, the right to be notified of the release of a victim's assailant, for example, in its constitution. 35 states include some version of victims' rights in their constitutions, but only 5 states, California, Illinois, Ohio, North Dakota, and South Dakota, currently do so using Marsy's Law. Georgia, Kentucky, Nevada, North Carolina, and Oklahoma all have this question on their ballot this year in 2018. Measures in 24 state legislatures have been made to adopt it. It has been overturned in Montana following a ballot measure, and a measure was introduced in South Dakota legislature to repeal part or all of the amendment. It should be noted that in 1986, the Kentucky State Legislature passed legislation addressing the rights of all victims, crime victims. That legislation, which includes KRS chapters 421.500 through 575, is also known as the Kentucky Crime Victim Bill of Rights. As of 2018, that has been amended multiple times, including in 1996, 98, 2000, 2006, 2008, and 2013. The law's proponents say they want equal rights for crime victims, and they argue that the constitutional rights of the accused outweigh the rights afforded crime victims under state law when the two clash. For instance, Marsy's Law includes a constitutional right to privacy for victims, a right to participate in the proceedings, and to protection from the accused if needed. Opponents, such as the KACDL and the ACLU, argue that Marsy's Law may be unconstitutional and that existing statutes already ensure victims' rights. And now for our speakers today. Our first speaker is Ashlea Christensen. She currently resides and serves as the State Director and Counsel of Marsy's Law for Kentucky. Prior to this position, she lobbied in Frankfurt and in Washington, D.C. for the Passport Health Plan. She runs a small family law firm, practiced criminal defense, and worked as a child sexual abuse therapist and DV rape crisis advocate. She's the proud mom of a strong, analytical, and only occasionally sassy 15-year-old daughter. They happily live in a renovated barn in the country with their ragtag family of rescue animals. Please welcome Ashlea Christensen.
Thank you so much. Crime victimization is something that's not very comfortable to talk about. But I want to make mention that as I look around this room, statistically, I know that there are some people in this room that have been victims. So I want to recognize that. Just here in Kentucky, there have been 23,785 felony convictions in Kentucky just in 2017. Those are convictions. Those are not crime reports. And those of us in the room that have practiced law know that it takes a lot to get a conviction. So I want to recognize that. According to Kentucky State Police statistics, homicides, forcible sex offenses, motor vehicle thefts, kidnapping, and abductions increased in 2016. Our justice system is absolutely not perfect, and I think we'll hear Rebecca say that as well, and I agree. But we are constantly working to keep the scales of justice balanced as the pendulum of society swings back and forth. I believe that when you leave here today, you'll understand that we as a state have done a tremendous amount on behalf of those who are accused and convicted, and it's time that we do something on behalf of victims. A victim is created at the time that a crime occurs, and he or she deserves certain rights. It's incumbent upon the system, law enforcement, and prosecutors to make sure that the right person is prosecuted. But denying victims rights as a solution to other issues within the justice system is not a solution to other issues within that system. So I want to expound a little bit upon who Marsy was. Marsy was a young college student. She was going to school out in California, but that family has deep ties to Kentucky. Her family lineage started in Kentucky. Nicholas County, Kentucky is named after that family. She would come back here often to ride horses. So when we say that they're Californians, their family have deep, deep ties to this state. Marsy got involved in a bad relationship. The young man was abusive. And when she tried to end that relationship, he proceeded to stalk and harass her. He threatened to kill himself, which those of us who have been involved in the system long enough know that is a very common tactic that abusers will use. She went to him to check on him, and he opened his front door and shot and killed her on his front steps. Thankfully, he was arrested that night, but unbeknownst to her family, he was released. And several days later, they ran into him at the local grocery store, and he threatened to hurt them as well. That's something that I know Kentuckians deal with all too often here in our state, and that's something that has to be fixed. So, what are the specific rights that Marsy's Law will entail? The reasonable right upon request to timely notice of all proceedings, the right to be heard in any proceeding involving a release, plea, sentencing, or other matter involving the right of a victim other than grand jury proceedings, the right to be present at the trial and other proceedings other than grand jury proceedings on the same basis as the accused, the right to proceedings free from unreasonable delay, the right to consult with the attorney for the Commonwealth or the attorney's designee, the right to reasonable protection from the accused and those acting on behalf of the accused throughout the criminal and juvenile justice process, the right to timely notice upon request of release or escape of the accused, the right to have the safety of the victim and the victim's family considered in setting bail, determining whether to release the defendant, and setting conditions of release after arrest and conviction, the right to full restitution to be paid by the convicted or adjudicated party in a manner to be determined by the court, except that in the case of a juvenile, the court shall determine the amount and the manner of paying the restitution, taking into consideration the best interest of both the juvenile offender and the victim. The right to fairness and due consideration of the crime victim's safety, dignity, and privacy, the right to be informed of these rights, and the victim shall have standing to enforce these rights. So something you're probably all wondering, and this is a question I get very often, is, wait a minute, don't victims already have these rights? Well, yes and no. As was mentioned, there was a statutory Bill of Rights passed in Kentucky many years ago, but we don't have constitutional rights for crime victims, and there is a big difference. There are levels of law in Kentucky. Many of us in this room know that, but that's something that I often have to explain when I'm out talking to people. There are constitutional laws, statutory laws, regulations, and ordinances, and they're very different in level of strength. Those who are accused and convicted in Kentucky have a multitude of constitutional protections. Those who are victimized have none. And there's something wrong with that. The difference in constitutional law versus statutory law is vast. There's a difference in the level of permanence. Constitutional laws cannot be changed at any time by the legislature, whereas statutory law can be changed during any session. It takes a lot to make a change to constitutional law. Constitutional law is enforceable, much more enforceable than statutory law. And it's much stronger and recognizable. I bet if I were to ask any one of you in this room, what are some of the rights afforded to those who are accused and convicted? We've seen those rights on shows, crime shows, If we watch NCIS or we watch Law & Order, we see those rights listed every single day. But before walking into this room, if I were to ask any one of you, what are the rights afforded to crime victims in this state? We'd probably be hard-pressed to list any of those rights. That's something that has to change. So where are we now? Some states have passed crime victims' rights 30 to 35 years ago across this nation. We are way behind here in Kentucky. Ohio, just in our region, Ohio passed their Crime Victims' Bill of Rights in the Constitution in 2017. And in our region, as far as constitutional rights go, the only state left is West Virginia. We have got to beat West Virginia. So, who supports Marsy's Law? 45,000 Kentuckians have gone online, taken the time to sign an online petition in support. Organizations and local elected officials, I could go on and on with this list, but I'll be brief. 5 congressional delegates, our Attorney General, Secretary of State, our Auditor, 48 legislators apart from passing the bill, 30 mayors, 62 city council members, including our Louisville Metro Council, 59 victim advocacy organizations, 11 law enforcement groups. These are groups like Kentucky League of Cities, Passport, NAMI, Kentucky One Health, Children's Alliance, Center for Women and Families, Kentucky State Police Professional Association. I could go on and on. These are all groups that have endorsed this law. The Kentucky Legislature, this is a constitutional amendment, so we had to pass it through the legislature before this goes on the ballot in November. Senate Bill 3 was sponsored by Senator Westerfield. It was passed 34-1 out of the Senate and 87-3 out of the House. And I want to remind everybody, there are criminal defense attorneys as part of the legislature. This was heavily vetted for 3 years in the state legislature. So speaking of vetting, like I said, 3 years, countless conversations and input from stakeholders, such as the County and Commonwealth Attorneys Associations, the League of Cities, law enforcement groups, victim advocates, and individual survivors. Notably, I want to mention that the KACDL was invited to provide input multiple times, but they declined. Countless individual meetings with legislators who were also attorneys took place. Numerous appearances in individual committees in an effort to identify questions and concerns took place. Extensive consultations with experts on victims' rights across the country took place. So what resulted was a very Kentucky-specific bill with very Kentucky-specific language. And I also want to note that not all Marsy's laws look the same. So if you were to look at the Marsy's law that came out of California or the Marsy's law that came out of South Dakota, it's not going to look the same as the Marsy's law here in Kentucky, and that's because our justice system is slightly different than that in California or the Dakotas. So what's still needed to pass Marsy's law? It's going to be on the ballot this November. You've heard the question that will be on the ballot, and my hope is that you will vote yes.
Thank you. Our next speaker is Rebecca DiLoretto. She is the Executive Director at the Institute of Compassion and Justice and the KACDL's legislative agents. That's the Kentucky Association of Criminal Defense Lawyers. Ms. DiLoretto has a 24-year career with the Kentucky Department of Public Advocacy in indigent defense. She served as the Post-Trial Division Director for DPA for 10 years and was the first director of the Lexington Public Defender's Office. She also served as the Litigation Director for the Children's Law Center, Inc. She has represented young people in juvenile, family, and circuit court across the Commonwealth and is currently an adjunct faculty member also at the UK School of Law. Please welcome Ms. DiLoretto.
Hello. First, I want to say go Ballard. My ancestors were the Ballards, so I have some roots here as well in Jefferson County and in the Commonwealth of Kentucky. I want to offer a beginning for my conversation of this by framing it with a woman, I'll call her Anita. She was born here in Jefferson County. She's about 43. She is 43 years old. She and her brother were born into poverty. Drug addiction impacted his life. She was sexually abused by her father when she was little. She got out of this environment, went to Lexington, ended up at UK, and got an undergrad in social work and a master's in social work at Asbury. And she worked for me in her different internships while she was in school. She called me 2 days ago because she was freaking out. Her picture was on the most wanted list in Fayette County, and she had an assault second-degree charge, and Tom had said that there's some among you who might be prosecutors or judges, but you might know that assault second degree is a Class C felony, so it's a pretty serious charge involving prison time. And she told me that she'd filed an EPO against her boyfriend for the abuse he'd caused her in court. The next day, she went to a jazz club with friends, and she was jumped by his current girlfriend and beaten up. So then, following the EPO, the girlfriend and the ex-boyfriend went to the Commonwealth attorney and filed a charge against her for assault second degree. And then thus she now was on the most wanted and was going to have had a warrant for her arrest. So I urged her to go and she said that many of her folks had called her and said, because she hadn't known about it, they said, this is up there, we all know what happened, we'll go to court with you. But of course, she didn't want to go to jail in the meantime, right? And she's desperately trying to find work. So, and knowing she's interviewing for jobs and knowing that this would impact those interviews. So I told her to get affidavits prepared and go to the prosecutor's office to see if they would, at least be prepared so that she could get this warrant lifted and deal with the case in court. She goes to the prosecutor's office with 3 affidavits and 1 witness with her. They say, no, we won't talk to you. You got to have a lawyer. So she goes and finds a lawyer and then goes back. And so then they're willing to, with the lawyer, they're willing to go to the judge and try to say, well, really, she shouldn't be put in jail for this. Of course, she's going to have to appear in court, but I don't know if any of you have an idea, but when you get put in jail for something that you didn't do or something that maybe you did less than what you're charged with, the ability you have to go and investigate your case and prove it is pretty challenging once you're locked up. So my goal was to help her try to forerun that. And if we put on top of what occurred to her, what's going to happen with the constitutional amendments we're concerned with here, that they've named, so persuasively Marsy's Law, what we're going to see is that what Anita was able to do in terms of avoiding going to jail, the case isn't dismissed, but at least she's being heard a little more than she might be otherwise, because it was so easy to bring this felony charge against her that could result in her incarceration for 5 to 10 years and her being locked up in a jail cell while she awaited trial. And that's the kind of thing we're really concerned about. And it goes back, as Ashlea indicated, she made the mention that KCDL had made no comments on it, which is pretty amazing statement, because I've testified at every legislative session on it. I've been to every legislator on it. We have presented to Senator Westerville, maybe he didn't tell you, all of our opposition to it from well before your involvement in it, so that certainly the proponents of the bill knew our opposition. So I don't see how one could suggest KCDL didn't express its opposition to it. So Marsy's Law is a constitutional amendment, and there have been efforts at the federal level to do this as well. Its impact will be on the 4th, 5th, and 6th, 14th Amendments of the U.S. Constitution. All of those are constitutional provisions that do have to do with the rights of individuals who are accused. And the big distinction between constitutional and statutory rights is that constitutional rights are intended to protect individuals against the power of the government. And much of what Marsy's Law is designed to do is to weaken the rights of an individual accused in the litigation between their position of what occurred and what the Commonwealth stated. If you go back to the roots of our common law, and certainly my ancestors and several of your ancestors might have come from Great Britain, where our law came from. And we have in Kentucky, it's called the Commonwealth versus John Doe and it is not the common, you know, like let's say that Susie was the one who brought these charges against Anita. The criminal charge is not Susie versus Anita. It's the Commonwealth versus Anita. And I'm going to describe why that's so significant, because the shift that we're talking about here, they sometimes call the criminal justice system a three-legged stool. There's the judge who is to act in a neutral and unbiased manner and make decisions. There is the prosecutor who stands for the interests of the Commonwealth, including that of the victim. And there's the accused, represented at times by a defense counsel, and sometimes they're not. But that's the three-legged stool. And our concern and the question being asked to us for this forum was whether or not this process will upset that stool. And our contention is very much that it would. And it isn't simply about jeopardizing the rights of the accused, but it also has to do with impacting truth-telling in our system. And that really begins with the ballot question. So I guess everybody here loves mom and apple pie. I know one of my teachers was a great apple pie maker. He was a man. So we probably like dads and apple pie too, but we all do. So the question as was read by Thomas is, are you in favor of providing constitutional rights to victims of crime, including the right to be treated fairly, with dignity and respect, and the right to be informed, and to have a voice in the judicial process? Yes. You know, Ballard, I hope that the Ballard School District is for this right, or I'm sorry, Ballard School, it's Jefferson County School District, but I hope you're for that right. We're all for that right. There's nothing wrong with that right, but that isn't what this is really about at all. And it's really highly disingenuous. So, and as was indicated, we've, since 1986 or so, we've had a Bill of Rights on the books. When I was in law school, I graduated in '85, and I did research for Sarah Welling, a professor at UK College of Law, on this question of victims' rights. And what happened to Marsy in California with respect to the, well, not that she was killed, because, you know, that happened before her parents failed to be notified of the assailant's release. That wouldn't have happened in Kentucky because we had a statutory set of rights, and over 100 of them. These are some things you're going to see changes in because of the pass, if this bill were to pass. So, and one thing for you to understand is there's this ballot question, and then there are this other litany in what Senate Bill 15 of rights. So there's a litany of specific rights. So one has to do with this crime victim's right to safety, dignity, and privacy. What will that impact? That will impact the defense counsel's duty of due diligence to investigate their client's case, talk to the alleged victim if they would talk to them, secure discovery. All of that will be subject to challenge for failing to accord that right. The rules of evidence in the Commonwealth will change as a result of this amendment. The accused person will have a right, has a current right to a trial that's free from unreasonable delay. But they also have a right to their lawyer being prepared. Well, under the constitutional amendment, there will be a right to speedy trial on the part of the victim. So if I, as defense counsel, am not well prepared, it may not matter, because what will matter is that the victim wants the case to be resolved. And one thing to consider is we aren't like California. You know, we don't have these enormous delays. And still, and today, the judges can push forward for us to not have unreasonable delay. You know, when you ask about what problem that this amendment is intended to address, the problem is prosecutors who aren't doing their due diligence to make sure victims are fully informed of everything. That's the problem that's being intended to address. Yet, the way in which the amendment is drafted, any government actor is protected from any liability with the passage of this bill. So really the only entity not protected against liability would be the private defense counsel. So public defenders would be protected, but private, because they would be seen as state actors, but private defense counsel never would be. And from the beginning, our contention has been, why don't you ratchet up accountability statutorily for prosecutors to do their job, rather than placing explicit language in this constitutional amendment that would protect prosecutors from any liability for their failure to act here. Let me see if I just want to, I know you want me to limit my time. I want to share. So one of the biggest things that this amendment does is to give standing to a victim to have counsel present at the hearings. And then then the question is going to be, usually you see the judge, the prosecutor, and defense counsel. Well, the victim would be entitled to have their own attorney present. What they don't do is describe how that standing will be exercised if there's not party status. So that's a legal term, but there's both standing and there's party status. And the way in which we question, I guess, severely how this is going to be implemented. And if you were to look at California, which was the first to pass this, they did an extensive study of it that we shared with Senator Westerfield and all the legislators who were considering the bill. Because the study showed that the implementation of this act in the end didn't protect victims any further than what they had on the books before. And a large measure of that was because of the enormous confusion regarding this question of what is standing versus party status. Another aspect of the bill is that it indicates that full restitution will be required by defendants. So currently under the law, we aren't supposed to have paupers prisons. So we aren't supposed to put people in prison if they pay what they can afford to pay. And that means judges have to be on them, on the convicted persons repeatedly to get them to pay. It's not an easy task. We understand that. But this constitutional amendment may shift that and may permit then for victims to make a demand that regardless of whether or not the defendant can afford to pay, then there should be sanctions and incarceration for their failure to pay. And perhaps what causes us the most concern is that the particularized language in Senate Bill 15 states that all rights for victims shall be respected and protected by law in a manner no less vigorous than the protections afforded to the accused in the criminal and juvenile justice system. So it's explicit that they want the same protections to an accused person who hasn't yet been convicted, or to the victim who's making these allegations, as the accused defendant who hasn't yet been convicted. They want that same level of protection. And when you make the amendment in our Constitution versus you have it in the statute, constitutional law would indicate that those amendments are going to have an impact on all the other rights involved. So when Senator Westerfield first presented this to the legislature, his statement was this would not in any way have, and I was present, and I can swear to it, but I could also find it on the legislative history for you. He stated it will have no impact on a accused person's rights. And that's just not accurate. In fact, it will, and in fact, it's stated explicitly here by saying that they shall be no less vigorously enforced. One of the concerns that's been raised a lot by criminal defense bar is whether or not then is every victim, alleged victim, entitled to counsel in the same way that an accused person is? And if so, how are we going to pay for that? Should that be what rolls out in the long run? But I think a present concern has more to do with the reinterpretation of what we call the Fourth Amendment, right to search and seizure, the Fifth Amendment, right not to incriminate oneself, the Sixth Amendment, right to effective representation, the 14th Amendment about equal protection and due process. We're gravely concerned that all of those rights are going to be impacted. I was told by Terry Brooks when I started to investigate issues regarding the school districts in Kentucky that I should follow the money. So I followed the money in looking at this bill and who's behind it. Yes, it's this billionaire sibling of Marsy who help to front money. But it's also Lewis and Clark Law School and the National Crime Victims Bar Association. So what they are about is supporting attorneys for victims. And they promote it, and you can read their material, and what they're about is amending our U.S. Constitution. If KCDL, if my work, I'm a legislative agent for KCDL, and if my job was to make money for lawyers, I love the bill. I am ready. I am more, I bet, you don't know how many victims I have helped in different ways. And I know the system inside and out. So lawyers like me are ready and running to take on these cases, and we'll make a mint off of them. But that isn't my role at the legislature. What I try to do is to speak to the impact on our system of justice and creating imbalances and inequities. And that's what this is going to do. Because unless we fund lawyers for poor victims, like really Anita is actually a victim. She's really, even though she's facing these charges, and there are others like her, and I'm sure anybody who's done domestic violence work has seen that type of thing. But that what we're going to see are lawyers for wealthy victims, but not lawyers for poor victims, unless we create another, like we have the Department of Public Advocacy, we create a department for alleged victims. So, thank you.
Thank you. And now we'll have two of our board members, Keith Larson, and there is Joe Arnold, will be asking questions of our panelists today. And the first question is from Keith. All right, Keith, fire away.
Great. We're getting a lot of questions about clarification of the language. And I guess either can answer this question. Does Marsy's law require the prosecutor to inform the victim of all upcoming court hearings? And sort of in that vein, how does a victim learn about the various rights that he or she now has as a result of Marsy's law?
Sure. I can answer that. So that's a two-part question. The first answer is the prosecutor required to make that notification? We changed the language. Under the prior statute, the prosecutor was required to make those notifications. Under Marsy's law, the victim would opt in to those notifications. And that change was made based on a multitude of conversations with so many different parties, survivors included, because of the triggering that often occurs with those notifications showing up on their doorsteps. So yes, it would be an opt-in system. However, the initial notification that would go to a victim is provided by law enforcement, as it is supposed to be done now, today, under statute.
And my work on this in the legislature for the last 3 years would lead me to assert that it was prosecutors who worked to get that language changed, and in fact it does weaken the voice of victims and their rights.
Thank you. Next question, please, Joe.
I'm going to combine three questions that I think have a similar vein and then ask both of our panelists. What is the cost to the court system to implement? Several states have identified costs to the state associated with implementing Marsy's law. Will there be costs to the Commonwealth directly as a result of that amendment? And finally, I think this goes to the same vein, given that victims already have rights in Kentucky, who makes sure that this happens? Who enforces these rights? So costs and who's going to enforce it in the long run?
You want to go first?
Sure. I would be happy to provide folks here with information. There wasn't that kind of fiscal note provided with this legislation as it went through. An example, though, in North Carolina is that the Administrative Office of the Courts indicated it's going to cost the courts alone $16.4 million to implement and $30.5 million annually. And in North Dakota, there was an estimated fiscal impact of $4.4 million, and then additional expenditures to be assessed in the future years. And then one of the big contentions and reason that in some states, after the ballot measure passed, then the prosecution and law enforcement together said they didn't want this was the question of who has to enforce it and how are we going to do it. The other earlier question, and one answer to that, in some states they have, just like we have the Miranda rights, they then have a card that they would hand out that lists the victim's rights, and that's also a cost that's been identified.
Any comment?
Sure. So cost is we have a unique situation here in Kentucky, and we're very lucky. The lion's share of costs that has come out of other states is because of notification. They have had to develop a notification system. We don't have to do that here. We have a robust notification system already in place. Now, I will say that that notification system is only as good as the information that's put into it. So the cost is fortunately not going to be there here in Kentucky. Now, there will be minimal cost, as Rebecca said, as far as the Marsy's cards that will be produced. But we're working with the AG's office to put some of that stuff into place through online sharing, and Marsy's Law is helping with some of that. So as far as costs go, it will be very, very minimal here in Kentucky, and we're lucky for that. And then as far as enforcement, as with any change like this, it is going to be a systemic change. There will be a few cases that come up in the beginning, and unfortunately those cases will hit the media, and it will cause a cultural shift in the justice system. And that's what it's supposed to do. The system is broken right now, and the system doesn't pay much attention to crime victims. The crime victims are kind of kept as an appendage in the justice system. And there will be a couple cases that come up, and as it should be. And unfortunately, those people will be held accountable, and who will be enforcing those are, hopefully, and this is something that I know some of us are working on, is pulling together some pro bono attorneys. So as far as only rich victims will be able to, no, absolutely not. And I know there are plenty of attorneys in our community, in the Kentucky community, that work to make sure that it's not just rich victims or rich defendants that have services. So no, enforcement will be. I hope that and looking at other states that have had these rights in place for more than 30 years, it's once those few cases come up, it smooths itself out. There is a systemic change that takes place.
So just to respond, okay, California's done this exhaustive study. It was done in the academic setting by unbiased neutral persons, and they said it hasn't rendered any change in the system for greater justice for victims. Bradshaw versus, to the other point about appointed counsel, Bradshaw versus Ball is the case that said you can't just go on the goodness of attorneys to take the cases. That's what we had in Kentucky before Bradshaw v. Ball, which said, no, if you've got a constitutional right to counsel, then we're going to have to fund it. And that's going to be a big difference here. And, you know, certainly, again, any of us could become that kind of advocate and that voice to get those rights. And I would dispute the idea that victims are not heard from. Kentucky law, Kentucky already has the right to timely notice upon request of release. Well, actually, it's not upon request, but it's timely notice of release or escape of the accused. They have the right for safety and to right to be informed of every hearing. So our current law provides for that. I have been at sentencings where the judge turns, and I would hope if there are judges here, you ask if there's a statement from the victim and they read it. The testimony before the legislature, without specifics provided, was that judges don't ever do that. And that isn't my experience. My experience is that judges say, because the victim is entitled to give their statement, or the prosecutor could give it for the victim, or they could give it in writing. Those rights are already very present. The prosecutor's offices have victim advocates in their offices. The police departments have social workers that should be there working for them to try to work with victims. So we would assert that victims are not, they're not the silent voice that's taped shut in our system.
Thank you. Next question, please, Keith.
Yes, we're getting a lot of questions asking you to expand a little bit more, both of you, on whether or not counsel will be appointed to the victims. And this questioner asks both, since the amendment requires protection of victims' rights no less vigorously than defendants, and we protect defendants by appointing them a lawyer, how will we go about appointing lawyers for all indigent victims?
Please, Ms. Christensen.
We would have loved to have included language in the amendment to provide to provide counsel for victims. Unfortunately, we're in a budget shortfall in Kentucky, and so that's just not possible. So no, attorneys will not be appointed for victims. So as far as that language where we say that they're going to be protected as vigorously, that's a legal term. So they'll be protected as vigorously as far as constitutionally. But no, attorneys will not be appointed. I wish, and I know Senator Westerfield and the rest of the legislature wishes that that could be the case. Maybe someday.
The language of the amendment, the Senate Bill 15, does not state that they will not be appointed. So it does state that they'll be represented as vigorously. And then it states the victim, the victim's attorney or other lawful representative, or the attorney for the Commonwealth upon request of the victim may seek enforcement of the rights enumerated in this section and any other right afforded to the victim by law in any trial or appellate court with jurisdiction over the case. I assure you, the Kentucky Court of Appeals, the Kentucky Supreme Court doesn't want to hear from pro se victims. I mean, that, you know, that they will bend over backwards to appoint indigent defendants, lawyers, because they do not want to have to mess with a case that isn't litigated by an attorney. Our other concern about this has to do with the conflict of interest it provides for prosecutors. And, you know, I understand how unpopular I can seem to be to everybody here, but to stand up against Marsy's law isn't easy. And the prosecutors that I've talked to weren't in favor of it, but none of them, they're elected, I'm not. So none of them were able to speak up against it. And what this provision does that I just read to you, the prosecutor has a duty to do justice, and that includes representation of the victim. But what this does is makes the prosecutor become the lawyer for the victim. So how can the prosecutor do that and do justice? If they think that he or she thinks that what they have before them isn't adequate to go forward, if they think that they ought to permit an evidentiary hearing that has to do with issues uncovering the sexual activity of the alleged victim because it's pertinent to the charges being brought, and that's a fair motion the defense has filed, yet now they're going to stand as lawyer for the victim as well as lawyer for the Commonwealth.
Thank you. Next question, please, Joe.
There are some questions as to how this law might affect sentencing. And in particular, in a time, I'll quote, in a time of heightened racial tensions, how will Marsy's law disproportionately impact communities of color? To both panelists.
Go first, or?
Sure. I think that it doesn't do anything to help that situation. And I think that what it gives greater power to victims who already have access to counsel and strength to make their voice heard. And it certainly does not. In fact, what it actually states, which to me I find remarkable, is it's explicit that that if these rights are not properly enforced, that the defendant has no right under the law to claim improper enforcement. I mean, that's explicit in it. So let's say that we have a situation where, and this may happen in terms of communities of color, where the victim doesn't want to see, you know, has asserted, prosecutor, I don't want you to do X, Y, or Z. The defendant at sentencing wants to bring that forward because the prosecutor is ignoring it. It's explicit in the language here that nothing in this amendment, quote, is to be deemed a basis for vacating a conviction or a ground for any relief requested by the defendant. So under current law, I will say, here's the perspective of the victim if somebody else isn't bringing it and it helps my client, the defendant. This explicitly prohibits me from doing that. Why are they doing that? If what we care about is truth, coming forward with transparency, and there's a failure to implement this, why isn't the defendant allowed to say, look, this victim here is trying to be heard and nobody's hearing him? But they're explicit in how they've written this, that they have no, the defendant has no standing to raise those issues.
Ms. Christensen?
Racial bias in our justice system is certainly an issue. And that is something that and I'm not speaking for Marsy's Law here, I'm speaking for Ashlea Christensen. That's something that I recognize. But that is a separate issue from allowing victims to assert their voice throughout the justice system. It's a complicated issue, right? I mean, there are crime victims who have been harmed deserve the right to speak and deserve the right to have a voice in that process. Now, it's incumbent upon our courts to weigh that out. And I believe in our courts to be able to do that. They do a fine job of weighing our defendants' rights every single day. And so I put my faith in our justice system. It's not a perfect system. It needs tweaks. It needs work. And that's what we're working to do every single day. And we'll continue to do that on both sides.
Next question, please, Keith.
If victims have a right to be protected in a manner no less vigorous than the defendant or the prosecutor's office, does this mean that the victim will have the right to reject a plea deal that has been negotiated by the prosecutor and the defendant?
You go first this time.
Sure. So this law does not give the victim control over the case. Prosecutorial discretion remains. The case still is the Commonwealth versus the defendant. So the victim simply has more of a voice in the case. The victim will simply be able to speak at any hearing where their rights are impacted. So if the safety is impacted, the victim will be able to speak. But no, if there's a plea that the victim is unhappy with, they may be able to speak, but it's still up to the court. If it's a fair plea agreement, the court's still gonna, say, okay, well, I've heard you, and now I'm gonna rule.
Ms. D Loretto.
Since the provisions here permit for the victims to go forward with and be involved in the appeal and have a voice all the way up, we would assert that it's going to be fleshed out what that voice means. But they're going to be able to continue to argue those things that they tried to secure at the sentencing that weren't secured, and try to have the plea bargain impacted based on that. In addition, again, going back to what I said about a conflict of interest for a prosecutor, if the prosecutor thinks that this is a fair offer, but he is also has been asked by the victim to represent that victim, then the prosecutor is representing two masters in terms of what they do with the plea agreement.
Next question, please, Joe.
Another practical question about how it actually works. How far down the family tree are these rights provided? In other words, the questioner asks, how would this right to be at trial for the victim's family affect the separation of witnesses if they were also a witness and not just a victim to a crime?
Would you like to go first this time, Ms. D Loretto, or Ashley, would you like to?
Sure. So the definition so what we did is we passed Senate Bill 3, which is the constitutional amendment, which is hard to change, as I talked about earlier. That's more difficult to change. But then we also passed Senate Bill 30, which is a statutory amendment to our current law. And that's easier to amend. So in that, we amended the definition of victim. And what we did is we changed, an individual directly and proximately harmed as a result of the commission of a crime classified as a felony. And then it goes into, if the victim is a minor, incapacitated or deceased. Victim also means one or more of the victim's spouse, parents, siblings, children, or other lawful representative. So it gives the court discretion. If there's a situation in which, I'm thinking through some of the cases I've dealt with. If there's a situation in which the aunt is the right person to represent that family, it gives the court discretion to deem that person the correct representative. Each situation is slightly different, and the court needs to have that discretion.
So what we anticipate is there will be litigation regarding those definitions and who's going to be the victim under the Senate Bill 30, that will be litigated in the cases as ancillary litigation as to who is to be identified as victims.
Thank you. Next question, please, Keith.
These questions sort of go together here. So this questioner wants to know, the language on the ballot sounds biased. Why is that? Who wrote it? And does this help either side's cause? And sort of the follow-up to that is, what are either of you or your organizations doing to educate the public regarding what the constitutional amendment will actually accomplish?
Would you like to?
Well, KCDL is litigating that very question because we think the language on the ballot is grossly unfair and misleading and disingenuous. And we certainly sought a presence on KT. with Renee Shaw repeatedly. I think myself and David Ward, our presidents, we were each given about 2 minutes apiece during the session. So they did a lengthy interview with, Senator Westerfield, and I think they did about a 2-minute, though we drove in the snowstorm to be interviewed, but that's how much they said they wanted to put on about it. So how do you make it popular to say that, that you're not for this type of constitutional amendment? And we're here. I've presented other places for it, but the most well-funded legislative effort in the last 8 years has been Marsy's Law. So you just Ashlea described all the different supporters of it. Back a year ago, when it was on the ballot, there were robocalls going all over Western Kentucky at the time of the elections regarding, well, this legislator's for it, this legislator is against it. And as she indicated, very few legislators could possibly think they could be voting against it and get reelected. So we would suggest that the amount of money that's gone into the passage of this, I guess I could feel decent to being paid for about a 1/4 of the year's salary. That we stopped it till it took 3 years to pass is a good thing. But I don't feel that good about it, obviously, that it's on the ballot.
Ms. Christensen?
As far as it being, it's a constitutional amendment. So the entirety of the language cannot be put on our Constitution. With all of that, if you've ever taken a look at our Constitution, the pieces are very brief. It's just a paragraph. So we had to parse down the language into just a paragraph. And so the people behind that effort were a multitude of groups, experts from other states. We had Senator Westerfield, we had LRC staff, we had, oh my gosh, so many different folks throughout the legislature. And this language was part of Senate Bill 3 that was passed through both chambers of the legislature. It was vetted through all of the legislators. This wasn't something that we created and just kind of tried to slide through there. This was fully vetted language. And this issue with the language being biased was never brought up before now.
That's inaccurate. It was repeatedly brought up. Law professors, I sought the opinion of law professors from Kentucky's law schools, and they know a lot. I don't know if anybody ever knew Dean Lawson. He was my dean, and they know a lot. And from every single law school, they were opposed to it, and they didn't testify before it. They brought law professors in from California and Oregon and West Virginia on this. David Niehaus, who is a Jefferson County citizen and worked for Dan Goyette's office for probably 30 years, and Kenyon Meyer, who is with Dinsmore and Scholl, are the chief litigators for KCDL that are challenging this language. So we have stated it repeatedly that it's disingenuous. It has been the first thing we've said with every appearance before the legislature on it and in our individual communications.
One more really short question, if you can, please, Keith.
Sure, and this is actually a perfect follow-up for Ms. D Loretto. It's my understanding from this question that the litigation to block the measure from the ballot wasn't brought until August. Do you know why it took so long to bring the measure?
Yes, we have no funding for what we do. So David Niehaus is doing it for free, similarly Kenyon Meyer. So it's just a little more challenging when you try to fit into your life the things you're undertaking without remuneration.
All right. I want to thank our questioners. I want to thank Ms. D Loretto and Ms. Christensen for having this program today. I think we've all learned a lot. In appreciation, each of our speakers today from the Louisville Forum, I'd like to present each one of you with a Louisville Forum Mint Julep glass.
Thank you so much.
Please give a big hand to our speakers today.
Tom, I just have to say, my children know I'm going to turn 60 in November, and I've told them, this is what I want, kids. I was like Lexington Rotary Club Person of the Year in high school, and senior, I got one. That's my other, and my brothers all got my families. There are 4 boys, 4 girls. My brothers got them. The girls did. So I'm going to see my 99-year-old mother who's at Nazareth Home. I'm going to show it to her. Thank you.
Thank you.
So much.
Thank you.
Thank you.
A brief note before we leave today. Our next meeting, due to scheduling conflicts with both of the candidates, our next meeting will be on the 3rd Wednesday, October 17th. But by moving it back a week, we will have the 3rd congressional debate between Congressman Yarmouth and Secretary Vicki Yates Brown Glisson. And so I highly encourage all of you to make early reservations. You know, as you know, we have a limited room with a limited space within this room, but I think it'll be a very exciting debate. And again, we had to move it for both of the candidates' schedules, but I really look forward to this debate, and I hope you all do also. Reservations may be made online at louisvilleforum.org or by calling our voicemail at 329-0111. Thank you all very much for attending today's program, and remember, be nice to people.